Justice Barrett?
Mr. Fletcher, so you've pointed out, and I agree with you, that it's interesting, kind of odd. It strikes me as unusual, but I haven't done a study to have an overbreadth challenge to a statute that's older, because all of these overbreadth challenges invite a string of hypotheticals, but as you say, we have a track record. Have you looked at it? Are there overbreadth challenges that have succeeded in the past where we have this much data?
So I don't know, candidly. I'm not aware of one of the court's recent cases where this has come up. Stevens, Alvarez, those sorts of cases are relatively newer laws. The reason I don't want to say definitively that there isn't one is that I think some of the earlier laws involved state statutes, and I just haven't traced back exactly how old they are. But I'm certainly not aware of anything where you have sort of the track record going the other way. Not only is it old, but also we have such a strong empirical track record against the very broad interpretation. And, I think that's relevant not just to overbreadth, but also to what the statute means, because Congress has been coming back and amending the statute and revisiting it against the backdrop of that narrow application of the statute.
Well, and speaking of state statutes, so we have some amicus briefs saying that lots of states have language like this. It's possible that lots of statutes would then succumb to First Amendment challenges of this sort. Have there been similar overbreadth type concerns litigated, especially since Sinning Smith, about other solicitation statutes or other induce and encourage statutes?
It comes up occasionally. They don't get a lot of traction. One example that we cite in our brief is the Ford versus State case out of Nevada, which is about solicitation of prostitution. Very similar statute. It was induce, encourage, or persuade, or coerce to enter into prostitution, and the defendant tried an overbreadth challenge there. I think we also cite a Minnesota case. So there are examples out there, but frankly, courts have not had much difficulty dismissing them, either because you can't imagine circumstances where the aiding and abetting or solicitation would actually be protected, or because even if you could, that's such a sort of edge case that it doesn't call for the application of overbreadth.
Thank you.